lecture today, we are going to discuss about the use of force. How the use of force has evolved, how it has been regulated, and what is the current status. When I say the current status, I mean the regulations which are currently in operation. So, this lecture covers this part of the course. I am Iqbalur Rahman. I teach political science in the Department of Political Science of Aligarh Muslim University. So, dear student, use of force is a historical fact. The fact is that it has been considered to be directly linked to the sovereignty of a state. The limitless power wielded by states to use all possible means available to them to guard and to protect their interest. For centuries, states have resorted to force in their relations in order to achieve their desired aims and objectives. The use of violence has proved, dear student, to be an accepted method of resolving disputes among states. A state reserves the right to wage war with or without any internationally agreed regulatory mechanism, regulatory authority. Nevertheless, over the period, over the time, the concept of just and unjust war emerged, which are no longer valid propositions. But in the past, the uses of force by states, they were categorized in the framework of just and unjust. And justness and unjustness of the act was the criteria to define, to limit, to regulate war. Use of force actually is not only limited to war. It is much more than war. It includes the uses of power, the power which is the basic idea in political science. And states are units of power. They strive for it. They use it to maneuver their own things, to get what they want. So this is struggle. The fact is that this reality is with us. States are there and they will always, in one form or the other, exist. And so, with them, the power and the uses of power. So, the management of power actually is the subject which states try to manage in the sense that somehow peace shall be established. And for establishing peace, war is also an available option. So, before the Treaty of Westphalia, 1648, a resort to force was interpreted and justified on certain grounds of morality and justness of the issue. In the light of the growing number of sovereign states, wars started to be seen and defined as a state of legal affairs rather than as a matter of subjective moral judgment. States no longer found themselves in a position to judge if another state's reason for resorting to force was just or not. Despite its existence, despite its extensive use by state, it is described as quite politically sensitive and legally much contested issue of state relations. It was the Treaty of Westphalia that created the foundations for the present day society of states. Before this treaty, there was a hierarchical system of power instead of territorial sovereignty. The concept of state sovereignty, mediation between nations, the diplomacy found their origins in the text of the Treaty of Westphalia. It established a system of rights and duties of the states. Dear students, sovereignty as established with this treaty meant that a state had legitimate rights over its territory, superiority in all matters ecclesiastical as well as political, right to declaring war, engaging in negotiations, and ratifying peace treaties. States continue to be sovereign. Self-defense continues to be as their inherent right, and to defend means to wage war, to use force and other resources available to them. The Treaty of Westphalia also dealt with the nature of war and its intended uses. It established a collective security system. This idea was not spelled out in exact terms in the treaty, in the provisions of the treaty, but was inherent within the wording of the treaty. Article 123 and 124 postulates for collective security. The treaty provided for the sweeping ban on the use of force, a prohibition on states' individual self-defense except after the expiry of long period of diplomacy, and the duty of all states to act in collective self-defense. The treaty obligated the signatories certain duties besides recognizing right to wage war. Resort to use force was not outlawed, though through this structure, the Treaty of Westphalia, attempts were made to regulate the use of force among the states. The idea itself was quite revolutionary for its time. So states overlooked it. They did not actually imbibe this idea into their policies, into their interaction with other states. But the fact is that This treaty provided, the treaty regulated, though not in exact terms, the regulation of use of force, regulation to prevent war, regulation to avoid war. This was the outcome of the Treaty of Westphalia. The charter of the treaty contained the principle of peaceful settlement. With this happened the change in perceptions of the states. Perceptions towards each other. States accepted each other as sovereign entities. There was the official recognition of the diplomacy. Though diplomacy was used in the past as well, before the Treaty of Westphalia, dear students, this is not something which we can say was invented at the time of Treaty of Westphalia in 1648. What actually is significant that the diplomacy emerged as an alternative to war. This unbridled practice of states to use violence to decide their matters was restricted. More and more use of diplomacy was there. It was available to them as an alternative to war. So as I said, that there was change in the perception. There was change in the perception in the sense that they used to recognize, rather they recognize the other states that they also have this same rights and duties as one state enjoys it. All were sovereign. All were supposed to be equal. For its time, as I said, this was a revolutionary idea, but it was a monumental achievement as far as the creation of the foundations of the present-day international order is in question. It developed the framework for international diplomacy. As I said, this was used by the states in place of directly going to war. So this engagement through negotiations, through diplomacy, actually helped them to avoid wars. Though the war happens, but treaty contributed much towards the regulation of use of force in matters of state relations. This peace was extremely influential down through the Treaty of Versailles, Kellogg-Briand Pact, and the United Nations. Along with these three treaties, many other instruments restricting, controlling the use of force, they also were signed. They also became part of states' relations. But in this course, we would focus on these three treaties. It was after the First World War that the legality of the war was questioned for the first time. I'm emphasizing legality of the war was questioned for the first time. As there was a lack of legal regulation, those who were held responsible for the war and put to prosecution were let free. The Covenant of the League of Nations proposed to promote international cooperation and to achieve international peace and security. The first of the means by which this object was to be attained was, according to the preamble of the Charter of the League, the acceptance of obligations not to resort to wars. The operative part of the covenant, following the preamble in several passages, expressly, openly binds the members of the League not to resort to war. League obligated its members to respect the territorial integrity and sovereignty of all others and to disavow the use of threat of force as a means of resolving international disputes. The League sought to peacefully resolve territorial disputes. This was first large-scale attempt to regulate war by the League of Nations in 1920. Article 8 and 9 of the treaty deals with Article 8 and 9 of the treaty deal with the armaments. All members wish to reduce their armaments to the lowest possible level to suppress the evil effects of the private manufacturers of arms and to exchange full information as to their existing armaments and their programs for the future. A permanent commission was provided to advise the Council on all military, naval, and air questions. Article 10 to 16, Article 10 to 17 embodied what may be called the central and basic idea of the League: collective security, together with the various procedures for peaceful settlements of disputes. Each member undertook, under Article 10, to respect the integrity and independence of all others and to join in preserving them against aggression. Article 11 declared that any war or threat of war was a matter of concern to all members, whether directly affected or not. Every member had the right to demand that the questions be considered by the Council and, if necessary, to insist on an immediate meeting. Article 12 of the treaty bound all members to submit serious disputes to peaceful settlement or to inquiry by the Council, and in no case to resort to war until these procedures had time to lead a settlement. Until these procedures had led to a settlement. Even then, if no settlement were reached, they promised to wait a further 3 months before going to war. The various methods of settlement, arbitration, legal procedure, or action by the council or the assembly were then set out in some details in Article 13 to 15 of the Treaty of League of Nations. Article 13 and 15 the various methods of settlement, arbitration, legal procedure, or action by council or assembly were then set out in some details. And these provisions included the establishment of a permanent international court of court. Under Article 16, all members promised to join in common action against any other which were made in violation of the covenant. This action was to take in all cases the form of economic sanctions as its primary coercive mechanism, and if this were not enough, of military intervention. This article also empowered the council to expel a member which violated the covenant. Article 17 extended the system so as to provide protection against and in certain conditions for non-member states as well. However, the covenant did not revoke the right of states to resort to war. It subjected this provision to some limitations, but this right of the states was not prohibited, not outlawed, not declared illegal by the League of Nations. We see that the attempt for the first time which was made by the League of Nations to regulate the resort to war, this was the treaty-based regulation. The other part of the regulation of use of force actually is under the customary international law. The customary international law, the law which is established through the practices of states, and the law which is created by the states through treaties, both have regulated the resort to war, but the subject remains quite controversial in both the laws. One approach under customary law is expansive one, and under the treaty law is restrictive one. This aspect has to be taken into consideration whenever we discuss, whenever we talk about, whenever we speculate about the use of force. And this conflict between these two systems of regulation of resort to war to the prohibition of use of force use of self-defense, that be taken into consideration. For today, for this lecture, this is sufficient. This is, I think, had given you some sense that how the League of Nations has just made attempts at the regulation of war itself. Thank you, students.